All right, that brings us to item number 2 on our agenda, which is a public hearing and recommendation to establish permanent zoning regulations related to recreational marijuana businesses. And Alan, turn this over to you.
Yes, Alan Giffen, Planning Director, and wanted to follow up from the meeting a couple weeks ago that we had on the 2nd. We heard a lot of good questions from the commission. We believe we've responded and addressed most of those or all of those questions in the staff memo here, but I do want to point out that our recommendation has changed from the workshop that we held a couple of weeks ago. And I have Colin Olivers here from the City Attorney's Office, who has helped us quite a bit in preparing the responses and the materials, and has kept an eye on what's going on with the Liquor Control Board and the state regulations. And I would encourage, Colin, any comments that you want to offer to jump in at any point here. I'll start, though, by saying that I wasn't going to run through this memo in detail. I think that it has a lot of detail that responded to many of the questions that were asked 2 weeks ago, based upon where we feel we are with a very limited experience, actually no experience whatsoever, with operating businesses in the city of Everett. Instead of making the interim regulations non-interim, I would say that the staff's position has changed to recommend that these remain interim for a 6-month period. Under state law, we can extend not a moratorium, it's an interim regulation. We don't want to use the M word. We can extend an interim regulation for 6 months and see if we have enough experience within that 6-month period to evaluate any impacts that would occur or we're expecting that may occur from these businesses, and determine at the 6 months out whether or not to adopt permanent regulations or extend them again based on a lack of information. Our intent is to make permanent regulations, so as was discussed at the last meeting, business people have the predictability that they need to invest in a business. So we did talk a little bit in the memo about the pluses and minuses of a permanent versus an interim regulation. There is in the second section toward the bottom of page 1, discussion about the differences between recreational and medical, and I think I might ask Colin just to briefly summarize that for us now.
Well, I don't know how brief I can be on it, but I'll do my best. Essentially, we're continuing to treat the recreational and medical systems as separate systems. There's some anticipation that at some point the legislature will likely fold the medical marijuana system under the recreational one, but at this point they have not. And it makes sense for a regulatory standpoint for the city to take a more hands-off approach with regards to the medical marijuana, simply because while the federal government has expressed some willingness to allow a well-regulated recreational system to go forward, the medical system is not restricted in the same way. There aren't really that many restrictions on how they're operating, and it's unlikely that the federal government views that as fully complying with the Controlled Substances Act. So we think it makes sense at this point, until the two systems are joined, to continue regulating them separately.
Okay, the commission asked a little bit about what some of the other jurisdictions in our neighborhood are, how they're treating the recreational marijuana, and we've got our immediately surrounding neighbors identified here: Linwood, Marysville, Mill Creek, Mukilteo, and Snohomish County. 2 of them have enacted permanent bans, Marysville and Mill Creek. Linwood has interim regulations that run through February. Mukilteo has permanent regulations that deal with retail production processing, and we've identified in some of the bullet points there the nuances of their regulations. And Snohomish County has enacted permanent regulations, and they allow the retail, the production and processing, both within urban and in rural areas, even on rural residential zones. And so those regulations are what some of our neighbors are doing. There has also been a bit of litigation, not much on the legislation side, but a lot on the litigation side. And Colin, would you mind talking a little bit about the litigation side?
Yeah, just briefly on that, I think there's probably mainly two developments that have occurred. The first was the Liquor Control Board requested a formal opinion from the Washington State Attorney General's office regarding the ability of a city to ban recreational marijuana entities from operating within the city. And the Attorney General's office issued an opinion that I-502 didn't preempt the normal zoning controls that a local government has, and affirmed the abilities of cities to both adopt zoning regulations or to adopt outright bans. Following that, and after the Liquor Control Board began issuing retail licenses, several jurisdictions were sued by entities that had been granted licenses by the Liquor Control Board or anticipated being granted licenses, and challenged the abilities of the local governments to zone them out or ban them. The biggest and most involved is involving Fife, and the ACLU has intervened, and the Washington State Attorney General's office has intervened on behalf of the state. And so that's sort of the leading legal case that's going on, and on basically putting it before the judge to decide what the law provided. The judge also sided with along the lines of the Attorney General's opinion that local governments could zone and ultimately ban these business entities.
Thank you, Colin. With regard to questions related to the Tier 1, 2, and 3 production and processing facilities, the memo outlines the difference in terms of the size that is allowed for either any of the three tiers, which the Tier 1 is what is currently allowed under the interim regulation within the city of Everett. Tier 2 and 3 are not permitted. Tier 2 would allow from 2,000 to 10,000 square feet of plant canopy within a building, and Tier 3 from 10,000 to 30,000 square feet. And there's a definition of what constitutes plant canopy. The Puget Sound Clean Air Agency, that was a question that came up. How are they regulating the production and processing facilities? And while I can't answer the question, we did provide a great deal of information that they provided us, pasted into this memo. And essentially, the Clean Air Agency does require permits for anything that would be growing marijuana, and the particulars for what type of systems business might be using would be reviewed individually by the Clean Air Agency on a case-by-case basis to see if their technology addresses the odor issues, and that is something they do have jurisdiction over through the notice of construction process that is summarized well in great detail in the memo. Wanted to point out a couple of things. We have had only one retail marijuana, recreational marijuana retail business approved in the city by the State Liquor Control Board. That's in the 1800 block of Broadway. No others have been approved yet. There are two maps in your packet. One of them identifies approved marijuana retail locations, and you can see there's only one big red circle on that map in the north part of the city with that 2,500-foot radius. around the 1800 block of Broadway, which shows, after you apply a lot of the state regulations for separation distances required from sensitive land uses like schools and playgrounds and so forth, what remains in the way of available area in North Everett for retail locations once you subtract the area within that circle. Since no others have been established, you can see in the shaded areas along Evergreen Way, Everett Mall Way, 19th Avenue Southeast, and a few other locations where there is zoning available for retail stores. None have been approved yet in the rest of the city, so this just shows one, that we've only got the one that's been approved and it's not operating yet, and two, that we do have a number of other areas that are available for retail sales. And you can also see by the size of that circle what a 2,500 square foot radius does, basically a mile diameter circle that would be removed from the map once any other retail locations are established within which no other retailers could be located. The other map is where the zones where production and processing are allowed, and it appears to me that it does not have the separation requirements from the sensitive land uses such as the schools and parks and other facilities that are considered sensitive land uses, or the 1,000-foot separation from residential zones. But these are the industrial and agricultural zones where production and processing are allowed. I apologize that we didn't apply all of the filters on this map. There is one Tier 3 licensee that has been approved outside the city limits. You can see at the south end of that map, south of 128th Street in the business park over near Puget Park, south of Mariner High School in that area. There's one processor or producer that's near the city but outside the city limits, nothing within the city. I would, let's see, make sure I've covered everything in the memo here. I think we have, but the one last comment is we did provide a revised Planning Commission resolution for your consideration. This, I believe, was emailed out yesterday to you. It's in legislative format that highlights the changes proposed from the previous resolution, and that is the staff's recommendation that you would adopt this resolution that would renew the interim zoning regulations for recreational marijuana businesses. So with that, happy to entertain any questions from the commission.
In reading the staff report on the issue of interim versus final, it indicated that the interim regulations could be extended for 6 months, but in your verbal presentation, you suggested that that could be extended more than one time. Is that the case? You can extend it more than one 6-month extension?
Yeah, additional 6-month periods are authorized under the law.
Again, it's our intent to make these non-interim as soon as we have some experience and feel we have a handle on it. But that 6-month extension is available to us if we're not ready to make them non-interim after the first.
My concern was that many of the things that you're hoping to see resolve themselves are dependent on legislative action, and we'll have a long session next year. And with the kind of the size of the workload before the legislature, wouldn't be unexpected to see them go into extra sessions. And if you extend it to May, then you may well be still waiting to see what the legislature has done at that point. You may have to do another extension just to get if the legislature is to produce any answers, just to get the answers they produce.
That's correct.
Other questions from the commission? Comments?
I would just like to thank staff and legal for the information that you've provided for us in the maps. I think it was really excellently prepared and very helpful. So thank you.
Thank you.
All right. Anyone?
Just a comment, it doesn't seem like there's a whole lot of difference between staying interim and, you know, I know that I can see the comparison and contrast, but as far as an impact to somebody who was, say, entertaining the notion of opening this type of business, you know, if it happens at the legislative level, it's kind of out of our hands anyway, isn't it? For the most part.
I would say no. As Colin mentioned, the city can use its police power to adopt regulations that are more restrictive than what the initiative allows, unless the state legislature were to preempt local authority. And at this point, the initiative hasn't done that. That's one reason why we're kind of waiting to see what the legislature might do.
But if we engaged in entertained possibly, you know, generating more restrictions, how would we do that? Just by watching and seeing what happens and deciding at that time if this is a problem, we're going to do something about it, and then, is that how that would come about?
I think that's true, and also I think when we were originally last before the Planning Commission and developing the interim regulations, I think the intent really was to attempt to address all the potential problems that we envisioned. So I think that the hope is that we don't have any problems, and we may decide that we may be able to rein back the regulations and open up more areas. But it's really, at this point, without knowing the potential impacts, it's a conservative approach to make sure that, you know, we don't have to try to kick somebody out of their current location because it is causing a problem, and instead can allow them in the areas that we think we're very confident that they will be appropriate.
So we're staying pretty neutral without relinquishing any potential authoritative action we might choose to take in the future. Thank you.
And just to clarify, if a business goes through the process of locating, us changing the regulations after this 6-month period or during the 6-month period doesn't impact that business as long as they've gone through the process and been approved, correct? So there is certainty to them in terms of opening and existing.
It depends upon the position that the city wanted to take. The city could take the position that it wanted to be more restrictive, and like we have amortized, for example, in the past, adult entertainment businesses, there would probably be some grace period within which a business would be allowed to recoup their investment and relocate out of an area if the city were to decide a particular area wasn't appropriate for retail marijuana locations, for example. Anything to add to that, Colin?
Okay, thank you. Okay. Questions, comments before we open up public comment?
Are we ready for a motion?
Well, no, we have to do public comments still, but just before we do.
Was the hearing left open?
We haven't started the citizen comment.
We had a
portion.
hearing last meeting.
That was a workshop last.
Workshop? Okay,
Yeah.
sorry.
Right. Okay, I have one speaker, Jamie Curtis-Smith.
Thank you, Jamie Curtis-Smith. I live in the View Ridge neighborhood of Everett. I just want to start first by saying I really appreciate Colin Oliver and Teresa Weldon's effort on this. This is, as you know, quite a complex issue, and in lieu of having a larger economic development strategy to help guide us through how to assist and facilitate marijuana business in Everett. I think they've done a stellar job using the limited resources that they have. I think it really is important to look at this as economic development and not through the lens of legal, which their sole purpose is to protect us from legal liability, or from specifically the planning department, which does a great job helping us make sure that businesses that are working here and doing business here are doing business the way we want them to be doing business here. But facilitating the emerging marijuana industry is really a matter of economic development, and it really needs to be looked at from these multiple lenses beyond just the two departments that are here. Specifically, what are the long-term ramifications through the health and safety and all these other issues that go on with our community, the environmental impact or lack of impact, and specifically the clearly economic development opportunity that we have going here. A new report just came out last week. The industry actually generated more than $7 million since July, operating at only 6% capacity. So the numbers that we're talking about here, the jobs created, the tax collection, these are things that cannot be dismissed. And when we sit here and talk about maybe even doing more restriction on top of the already restrictive interim regulations that we have, it concerns me a little bit. It concerns me that we really are not understanding the impact that this industry is going to have on our community. Now, I understand that none of us have experience in knowing or having foresight as to what this industry is going to be, but we do have other models that are showing us the larger scale impact, Colorado being one, Uruguay as a country, legalizing marijuana being another, of course, Amsterdam, Canada. We can look beyond just our borders within Snohomish County, which I want to address maybe some of these point by points just to give a little more clarification to some of the things that Colin was talking about, starting with point number 3, which was, other jurisdictions. So when we talk about permanent versus interim regulation, I think it's important to understand a larger political effort that's happening here. The AWC has got a strategy right now to encourage cities to stay in moratorium, to uphold their bans, or to continue with interim restrictions, because what they want to do is go to the legislature, which is a brilliant strategy, but they want to go to the legislative session and say, look, we have X amount of communities here with restrictive policies, and it really is undermining the effort of I-502 to get established as an emerging industry. And what they're trying to do is establish their political power to say we need some funds, some of this tax revenue that the state is collecting, to be trickling back down to the local communities. I think it's a great idea. I think it's going to be very effective, but I don't think that we should consider what other cities are doing when those other cities, we are the largest seat in this county, and they are looking to us to take some leadership position on how we're going to structure this economic development opportunity. So I think that understanding some of the other intent and looking at what other cities are doing is important, but I also think that we need to put that into context of a larger political strategy that's happening. On point number 5, let's see the difference between Tier 1, 2, Tier 2, 3 facilities. I can talk on this all night, which I will try to keep it brief. But first point of clarification, the Liquor Control Board has capped the plant canopy at 70%. It's their way of trying to control or keep control over what is going to be available on the market, as they're realizing we don't have enough. So they will probably be lifting that 70% capacity at this point. So for example, a Tier 3 at 30,000 square feet could technically only have a plant canopy of 21,000 square feet. So looking at this again from an economic development strategy standpoint, if by limiting just to Tier 1 operators, yes, this is going to be a couple $1 million a year business that we would have here. Yes, it will employ probably 5 to 8 people, all fantastic. But compare that to a Tier 3 operator, which will be tens of millions of dollars, and at minimum employing 30 employees. The maps that we have here are very beautiful, very, very well done, but they don't tell the whole story, and this is what I tried to convey 2 weeks ago. although we have zoned them okay to operate in these areas, the actual physical properties, those parcels within those zoned areas are not, many of them are not I-502 compliant anyway. Remember, we don't have just the legislator that we're being dictated by. We also have the Liquor Control Board with extensive regulations on how business is done and what is going to be allowed. And most properties in the city are not I-502 compliant anyway. So any additional restrictions that we put on are basically telling the industry, we don't want you here. And that is why when you walk over across the street to Snohomish County, you will see lines of producers, processors lining up to do business in Snohomish County, and you hardly see anybody over here. By having this 2,500 square foot separation that already continues to restrict where people are allowed to do business here, and as well as limiting it to tier 2 and tier 3, it just doesn't make economic sense. And nothing that I've heard here tonight as far as how it's going to look, what it's going to smell like, all those other things, I don't understand still the logic of that restriction. So I really hope the commission really consider the economic development impact of limiting just to tier 1 operators through this next 6 months, maybe even a year out. As far as point number 6, the Puget Sound Clean Air Energy, they are requiring permits. This is almost a flashback to the Stamp Act of the 30s, where they are requiring a permit, but they're not sure how to do that yet. So producers and processors have been told by the Liquor Control Board to continue business as usual, apply with the application that they do have online, but behind the scenes, the Puget Sound Clean Air Agency is still figuring out what that looks like to offer a permit. It will come, everybody's aware of it, it's not a problem. But remember, at the core of this industry, we are creating a plant. This is a crop. This is an agricultural crop that this plant produces oxygen. So granted, I know on this side of the state it is indoor, so we're not going to have the benefits of the sun grown for the most part, but just something to keep in mind. But again, that additional layer of regulation that is already acquiring is just, I think that will take some of the concern off, hopefully, of the commission to enact even more restrictive regulation. Let's see, okay, so summarizing again what I said from 2 weeks ago, and I'd like to say that again, is thank you for, or please extend the interim regulation. I think that the AWC, this is a good strategy. It would help support their cause to help trickle down some of that money that is being collected by the state to local if we do have some sort of non-permanent regulation in place. I think by us holding to an interim regulation, they can count us as a city that does not have permanent regulation in place, especially when they can come together with all these other cities. So I think extending the interim is the right thing to do, with the condition that we do lift the tier 2 and tier 3 restriction, and instead, if we want to feel like we're having control, additional control of the industry, as we see things come through, we should use the conditional use permit process. I think that is a much more valid way to go than just banning, as well as bringing tier 2 and tier 3 in here. It will allow us to actually collect information. We will be able to see the difference between a tier 1 and a tier 2 or 3. What we're really talking about here is a tier 3 is a Budweiser and a tier 1 is Scuttlebutt. It is a completely fundamental different business model. Both are extremely valid in this industry. They're both in completely different market niches, but they are fundamentally different. And by us just limiting the tier 1, I think we're doing a huge economic development disservice to our city. So with the delay, just lift the restrictions that we have and push forward our interim regulations. One more thing is, because we are buying ourselves 6 more months to collect data and study, all of this industry, the future of this industry, working in Everett has landed on 2 people's desks, Colin Oliver and Teresa Weldon. And I really encourage this commission to please free up some resources for them to actually participate in a larger conversation within this industry. pull together some advisors for them, send them to networking events, put them on a tour, go send them out to large-scale producers, go send them to processing facilities, go visit some retail shops, talk to people within the industry. I think they're doing a stellar job, but I really also believe that they need the support of the city to regulate and suggest and come up with regulations that would help them do a better job. Not to say you're not doing a great job, continuing to do a great job. Okay, and I think that is everything, but I am certainly available for questions if the commission has any. I'm here.
All right, thank you very much.
Thank you.
All right. Anyone else like to speak? Okay. Hearing none, do I have a motion to close the public hearing?
So moved.
Second.
I apologize, but I think as the alternate, I don't know that I can have you second on it, so I appreciate the,
I'll second Commissioner Soson's motion.
great, thank you.
Yes.
Commissioner Jordison? Yes. Commissioner Sand?
Yes.
Commissioner Sosin?
Yes.
Commissioner Olivers?
Yes.
Commissioner Stewart?
Yes.
Chair Adams?
Yes. All right, any discussion from the commission?
I just have one question to staff. So if the legislature does intend to enact, that the city can't enact these regulations, interim regulations we have now, or are opening it wide open, and we still don't have that sample set that we need in order to identify if there is any community impacts. I'm just curious if an interim regulation would sell us short to having some kind of a permanent regulation, or is that something we have to come back with immediately after the legislature makes its decision, or we see what route they're going towards to enact some protections for our community? Or I just don't want to get caught in an area where permits are in and they're getting issued and we still have these concerns in place based on what the legislature might do, if that makes sense.
I'm not sure I followed 100%, but I guess I view it as an all or nothing. I mean, the two options really are the city has police power authority to regulate these businesses, or it doesn't. I personally would not believe that the legislature would do that. I mean, that would take away all regulation that the city has, including, the distinction between residential zones and commercial zones. But I think it's mostly an all or nothing proposition. So having permanent or interim regulations at that point probably wouldn't really have any distinction.
I bring it up because I know the fear was in Marysville, who actually enacted a ban, and actually I was staff the planning commission, and actually advisory committee is part of that. And after the planning commission actually made their recommendation to the Marysville City Council, the fear by the council is that we're not going to be able to enact any certain regulations or whatever. So the planning commission actually went back and reviewed development regulations similar to what we have before us tonight, although a lot different, but ultimately tabled that based on the Attorney General's decision and all that. So I was just curious what your opinion might be if in the future, if we're stuck or we just fall through the cracks and not having that big sample set for community impacts. So thank you.
So one opportunity we have this evening is to pass the proposed resolution, but we also have the opportunity to make changes to the resolution. And I'm wondering if we were to change in Exhibit A under number 5 and number B5 and C5 to change the distance of separation between producers, processors, and retailers from elementary schools, playgrounds, rec centers, things of that nature, from 1,000 feet as it is now to 1,500 feet. If that would be a problem with still having enough opportunities for retailers to locate in the city. know we don't
As I
have-
understand the question or the suggestion is to change, is it the production and processing, increase that from 1,000 to 1,500 feet?
And also the retailers from 1,000 to
Oh,
1,500 feet.
from separation from sensitive land uses.
Yes.
We haven't done that mapping exercise to see what that would leave in the way of additional spots or sufficient spots for businesses to locate. We've done the 1,000-foot separation between producers and processors and residential. Unfortunately, the map, we have done a map that applies all the other 1,000-foot filters from sensitive land uses to the producers and processors, but we don't have that with us tonight. But we haven't done anything at a 1,500-foot separation for either the retail or the production and processing.
So could an option be to pass the resolution as has been drafted and then have accompanying the resolution a comment from the Planning Commission that we would like to see those separations increased, but lacking the information tonight, we didn't make that change? Or maybe just the minutes will reflect that.
The minutes, as you know, Kathy does a pretty
Very good
detailed job of the
job.
minutes, and it will reflect the discussion, whatever the wishes of the commission might be.
And I guess if I could add real quick, on the retail locations at least, while we haven't done the mapping, most of the areas that have curved lines are because of the setback requirements. So there are a lot of small slivers that are currently available that probably would be knocked out if the restriction was increased to 1,500 feet from sensitive uses, just because many of those sensitive uses are spread pretty widely throughout the city and are often fairly numerous.
Does that answer your question, Lauren? I think.
Yeah, it does. My preference would be to increase that separation from sensitive areas. I think that's an important aspect for the city to consider. And I was rather surprised when the one retail came in kind of right smack in the middle of the part of Old Everett, I'd call it. And so I would be in favor of changing that dimension, but I also understand that we probably don't have time to go back and revisit the maps at this time, so.
In order to keep the interim regulations intact, we do need to get this back to the city council with action by the commission, whatever that may be tonight.
Which I think is more important, the most important action to take is to.
Okay.
Brief comment, or an affirmation requested. If we pass an interim regulation for 6 months, or even extend it 6 months more, pending some legislative information and some legal case settlements, we can also loosen up these regulations at a future date as well, if we wanted to, a year from now, include Tier 2 or Tier 3.
Yes?
We would have that option.
Yes.
Okay. Thank you for that. My other comment is, with all due respect to the argument of this being an economic development potential. I think there is potential, but I do not believe right now that we have enough information from the legislature to know how the city will benefit from taxes, if any, and or what kind of family wage jobs and employment numbers that some of these operations reflect the potential of. So I think it is possible that the city would benefit. I would like to have more information and more under our belt track time to really know, because we have such limited developable industrial land in the city. If we have a choice between an industry sector that, has very high family wage jobs, engineering, aerospace, and that sort of thing, and something that is not as dense in its potential to help the city, then, it is certainly an economic development strategy and question, but I want that information before we make those decisions. So the interim regs as is do it for me if the city feels that they're protected. And time would tell if we need to include Tier 2 and Tier 3 producers and processors and/or increase setbacks from sensitive uses. So I'm satisfied with the way it is right now, at least for another 6 months. And hopefully we know more.
Largely for the reasons enumerated by Commissioner Sosin, I think I support the extension of the regulations in the format presented to us. If I were to have the opportunity to work with the commission to make modifications to these regulations, frankly, I'd probably be inclined to support reducing the separation between retail locations. I unfortunately wouldn't agree with Commissioner Sand on increasing the setback from sensitive uses, because if it would end up looking essentially like a moratorium. There may be 1 or 2 places left available, and if a moratorium's the goal, then we should be honest and clear about that and propose that the council adopt a moratorium. And I would also support allowing Tier 2 and 3 production facilities. But for the reasons stated, it seems like unless the city has these kinds of issues yet to be addressed, they really don't have much bargaining power with the state with regard to shared revenues, and there really isn't anything in it for the city if there isn't any state shared revenue from this from the various tax streams.
I guess I'd like to note that in the draft resolution, point number 6, does report that the city, as I'm reading it, hopefully I'm reading this correctly, that the city has been approached or heard of 12 Tier 2 applications, and it also talks about 9 Tier 1 applications, but it's silent on whether or not any Tier 3 applications have been pending or if that's something. So I'm wondering if, because I'd like these 6 months extension to be the most valuable for gathering information, and if we're not entertaining new businesses, then we won't get that information other than looking at other jurisdictions and finding out what's happened with those situations. So I'd like to just suggest that since we have been approached for some Tier 2 applications, we might differentiate between the Tier 2 and the Tier 3. If anybody's open to that now in terms of the resolution that we're looking at tonight, perhaps considering allowing Tier 2, but prohibiting the Tier 3 at this time for the next 6 months, and then we'll see if somebody steps forward with the Tier 2, so we can gather that information about the impacts. And then another question that I had that was mentioned in the testimony we heard was regarding the future, if this would be subject to a conditional use permit later on, if we're envisioning having special conditions. If staff has any thoughts about that?
Alan Giffen, Planning Director. The thought of regulating Tier 2 or 3 production and processing facilities with a conditional use permit does give the city a little bit more of a handle on dealing with impacts with regard to a specific location or specific building or perhaps a process that we learn about during the review process that a producer or processing facility would use that might lead to some additional mitigation that might not otherwise be available to us if these were permitted by right without that additional scrutiny. It would, conditional use is typically hearing examiner review, or in some cases, a lesser review through but a public review with public notice that planning director is responsible for issuing a decision. So either way might be a way to, if you are considering allowing for the Tier 2 or 3 in the interim, that would give us a little bit more authority over regulating impacts.
I'm going to just chime in with Commissioner Oliver's. I don't really have a dog in this fight, so I'm not really taking much issue either way, but I'm also very sensitive to Commissioner Sand's concerns and possible trepidation about the whole issue coming to town. But my goodness, they just can't keep it on the shelves down in Seattle. And they seem to, as soon as they open their doors, it's all, within a couple hours, they're all sold out, And if we were selling, if you could sell Chevys or Fords that fast, my goodness, what a great boon that would be. But I know it's not the same thing, but there is also, and I won't engage in sort of social commentary, but, there is a certain amount of hypocrisy in the fact that you can sell, we actually have distilleries in Everett, and, you can sell hard liquor in a supermarket, but, and you can sell tobacco, and those things are really bad for you. So, my feeling about it is that, obviously want to keep all the options of, and controls that we can possibly afford ourselves, but at the same time, keep an open mind and not be prejudicial about the issue. So I think the interim, I think with suggestions that Commissioner Stewart had are probably good, and I'd be happy to go forward with the interim resolution in that manner. So I would even entertain a motion.
Just to be clear, are you making a motion or?
Pardon me?
You're not are you making a motion? I just want to.
When the appropriate time comes about, if everybody's finished their comments.
Alan, if we were to allow Tier 2 and Tier 3 processor and producers within the city limits, whose rules still apply? The liquor board's rules and our zoning, as well as adding a layer with special use or a conditional use permit?
The conditional use permit would be city rules, and so both the state rules and city rules would apply, as would Clean Air Agency regulations as well. And so a conditional use process, or we call them special property use permits in the city, would be either, and that's one of the questions I have for you if you're going to recommend allowing the Tier 2 and 3 by a special property use permit, if you want that to be a public hearing before the hearing examiner, or a planning director review in which there is notice provided to surrounding property owners, and public comments are taken in writing, but not a public hearing. That distinction between those two processes needs to be discussed too.
Additional comments, questions?
I don't know what the alternate can.
No. You're welcome
What
to.
was the logic of keeping 2 and 3 out?
I think it was just to take a conservative approach at this initial stage to see if there were impacts as a result of any Tier 1 processing facility with regard to odor in particular, or any other unanticipated impacts that we didn't foresee. And if we did have impacts that we could then scale those to a 2 or a 3 if down the road we decided those could be addressed or permitted without the impacts.
And I think another thing that the lady said it was valid is the training or giving some staff time, you know, to go educate on this as opposed to trying to look at barriers to slow it down or get rid of it, you know, if it does, if it is a good thing.
Well, staff's position is to provide that information to the Planning Commission. Once we have that information, and again, this is a fledgling industry that we don't really have information about. Once we gather that information, which we're happy to do, and present that to the commission, it would be up to the commission and ultimately the city council to decide whether to take a restrictive or a permissive approach to just go along with the minimum regulations established by the Liquor Control Board, or if we wanted to establish something a little bit more restrictive or protective, however the community may evaluate that.
Alan, question about current inventories, buildable lands in the areas that, of zones that Tier 2 and Tier 3 processors could potentially cite. Have we looked, as a city, as a staff, have we looked at what is available and whether we even have the potential for those kind of businesses? Mrs. Curtis Smith has said that even though we have zones available, there's no buildings or no land that would actually comply with the Liquor Control Board. And if that's the case, then I wonder why we're working on this right now.
Yeah, I would say that we don't have, I would say that we do have sites and buildings that could be made available that do comply with the separation from sensitive land uses. Unfortunately, the map that we have on production and processing didn't apply those filters that the state has established, but you have some very large tracts of land that would be far separated from any sensitive land use in a couple of areas, most noteworthy out in southwest Everett. There are some vacant parcels out there. There are buildings in that area that probably could be made available for tenants to locate in with a production or processing facility. Less so in the north end of the city where the inventory is a little smaller in land, but there are still a lot of buildings, for example, in the Everett Station area that would qualify. However, if you look at the Everett Transit Station, that's one of those sensitive land uses that would apply a filter around that, and so that area becomes much less acreage available for those facilities.
Okay, thank you. My thought is that there's some time of the essence needed to get an interim regulation passed, and my still current opinion is that we just don't have enough information to make any wise decisions about increasing restrictions or lessening restrictions until we get a little bit more information and maybe knowledge about what those decisions might inspire. So I would be in favor of, and I'd like everybody's opinion, my fellow commissioners, to know if they're comfortable passing the recommendation as we currently have it, as baseline protection for the city as the industry and then, legislative scene kind of clears up. And in the 6 months, we specifically look at Tier 2 and Tier 3 production, how it would affect our buildable lands and available retail or real estate inventory, as at the same time getting the information we need to know what these businesses typify in terms of family wage jobs, numbers of jobs typical to those kinds of industries to, decide if that's a good decision for us from an economic development strategy standpoint. And also, I would leave that as an opening for whether in 6 months we know that we really do need to increase the setbacks to sensitive uses. I want to stay squarely on the fence till we know more. Thank you.
I appreciate those comments, and I want to add to them my support, because I think I struggle with some of these issues in terms of the timing of it, but I think it all comes back to, I think we have a really good recommendation from the staff in front of us, and I appreciate the level of thought that went into the documentation that you've given us for today's public hearing. So in terms of what your fellow commissioners believe, I believe that strategy, from my perspective, gives us the most control and thoughtful process as we move forward. So I appreciate your comments. Any other? Okay.
I'm okay, but I need to understand how we're going to learn about 2 and 3. If we don't grant them the ability to come in and show us what they're going to look like, are we going to go to Colorado, or are we going to go to Kent, or, how would we get that information? And I liken this to my position on the Puget Sound Airs Advisory, where body shops, the bigger the body shop is, the better their pollution control technology, and they're more vibrant. I certainly don't want to beat the guys that are working in their backyard and stuff, because we all have to start somewhere, but they're more attuned to the regulations, and they're going to follow because they got more risk if they don't follow it. So that's where I'm kind of torn of why, where are we going to learn the information on 2s and 3s if we're omitting them from our process?
I think it's a good question, and what I would point to is the fact that we have the Tier 3 that's going to open just outside of our city limits. And I think in terms of if we have some Tier 1s that open in the city limits, potentially, but certainly the Tier 3 just outside, we're going to see some of those impacts on our city limits just because of that close proximity. I think it's a great question.
That's within the county, Chris?
Yeah, I think that's the one that's at 132nd Street, just south of the city limits. I think it's a great question, though.
And will a county share, do they share?
They share information with us pretty freely, and we could even contact the business just to see if we could learn, once that business is up and running, what the impacts might be.
Thank you.
Okay. Additional questions, comments? We also have a proposed resolution that was recommended from the staff in front of us, too. So if there aren't any more comments or questions in general regard, maybe we can focus our attention a little bit more on the proposed resolution that we have. I think I am.
If you're ready for a motion, I'll move resolution number 1410 as presented to us at Places this evening.
I'll second.
All right. Further discussion, questions, proposed revisions? All right. Hearing none. Kathy?
Commissioner Holland?
Yes.
Commissioner Jordison?
Yes.
Commissioner Sand?
Yes.
Commissioner Sosin?
Yes.
Commissioner Olivers?
Yes.
Commissioner Stewart?
Yes.
Chair Adams?
Yes. That concludes our item number 2 on our agenda, and unless, Ellen, do you have any housekeeping issues to cover?
No other housekeeping issues. Just would appear for the meeting of the 7th that we would be talking potentially about 2 items. One would be the code amendment that we discussed regarding the block on Pacific and Rucker at the meeting of the 2nd. The other item is a potential amendment to the Footprint Trinity Lutheran housing proposal, which would, for purposes of satisfying a lender, not limit the housing to student housing, but I don't have a letter yet in from the proponent on that to confirm that we'll be meeting on that. But we will confirm something next week to give you a couple weeks' notice of that. That meeting would be 3 weeks from tonight.
Perfect. Thank you, everyone, for the discussion on the agenda items. I appreciate the detail that everyone has put into this in terms of comments and consideration. So any other questions or comments from the commission?
Sleeping report?
It's limited. Baby and wife are doing great, though. They're both doing great. So, all right, we'll adjourn. Thank you, everybody.